My name is Bill VanCanagan, V-A-N, capital C-A-N-A-G-A-N, with the law firm of Detsopoulos, McDonald & Lind in Missoula, and I represent the Montana Association of REALTORS. I'd like to just take a few moments to provide the committee with some brief background, maybe to add a little bit of detail to supplement what Senator Rosendale just presented, that I think will be helpful and place in context the amendments which are before you today. On August 17th of 2009, the Missoula County Attorney submitted to the Montana Attorney General a formal request for an opinion. The request pointed out that both Missoula County and the City of Missoula had at that time different interpretations of the law with respect to what constituted a subdivision for rent or lease. The Missoula County Attorney in the request expressed particular concern about situations in which no dwelling is planned for residential purposes. In other words, outbuildings, storage facilities, any structure on a tract of record not intended for residential purposes. In addition, the county attorney pointed out that the two jurisdictions, the city and the county, had different interpretations of the exemption for, quote, sale, rent, lease, or other conveyance of one or more parts of a building, unquote, as set forth in MCA section 76.3.204, which is the exemption which applies to subdivisions for rent or lease. The county attorney emphasized that the disparities in the interpretation of the law, particularly where the city and county share a planning board and a staff for these issues, had caused, quote, confusion and disruption in our local governmental procedures and among affected citizens, unquote. The county attorney requested advice as to whether a subdivision for rent or lease in which no dwelling was planned would be subject to the subdivision review process. He also requested an opinion as to under what circumstances the exemption under 204 would apply, and also requested advice regarding the requirement for subdivision review if parts of one building on a parcel are to be rented or leased. So, very succinctly, the city believed that the exemption set forth in Section 204 applied to more than one building on a single parcel. The county disagreed and believed that the exemption was confined only to parts of a single building. So on January 13th of 2012, approximately 2.5 years later, the Montana Attorney General issued his opinion. The opinion provided two specific but very clear holdings. The term subdivision under the Subdivision and Platting Act does not refer only to a division of land for purposes of providing a residential dwelling. That was holding number one. And secondly, the exemption in 204 does not apply to the construction of more than one building, structure, or improvement on a single tract of record. The opinion of the Attorney General was carefully crafted, it was well thought out, and it cited the Rose case, which was previously decided in Ravalli County, in which Judge Langton held that a landowner who had constructed 4 cabins on his property for rent had to go through subdivision review. Now, although this opinion was well-reasoned and grounded in strict interpretation of the statutory language, it also had or created certain unintended consequences. And these consequences were incurred both in cities and in counties. Some of you on the committee, Senator Malik, perhaps Senator Barrett from Missoula, may be familiar with the apartment community on Russell Street in Missoula. This was a property which was purchased by the developers from the Missoula Redevelopment Agency. The property was formerly an old lumber yard. It had been designated by the city for redevelopment. This property was fully zoned for residential purposes, and for this reason, the apartment community had, in fact, been approved by OPG. The developer had worked closely with the city for 2.5 years to implement this project and had incurred substantial cost in that process. And the project included favorable financing attributes, including tax increment financing and a USDA guarantee. But unfortunately, the project contemplated the construction of more than one building on a single tract of record, and so on the day that the AG opinion was issued, that project was shut down for the reason that it had not gone through subdivision review. Now, we were able to work cooperatively with the city of Missoula, including the city attorney and Mayor Engen, to resolve that issue by submitting what is known as a detrimental reliance petition. It's a legal claim which indicates that the developer had relied to its detriment for a period of years on the state of the law, which was then changed to its detriment, and ultimately the project was approved. The bill before you contains a specific amendment that's designed to address problems such as this. It contains a specific exemption which states that structures which are in conformance with applicable zoning are exempt. There are literally hundreds of buildings in all shapes, forms, and varieties scattered around the state in various communities which were constructed prior to the issuance of the AG opinion. And many of these structures are now not in compliance with that opinion, and they're subject to substantial enforcement action. Many of these tracts of record are owned by small landowners who have constructed mother-in-law apartments or woodsheds who are out of compliance with the law. So the bill before you contains a statutory exemption for a maximum number of buildings on a single tract, which exemption is designed to address that issue and to bring people into compliance going forward. These are issues which I point out by way of example because they require comprehensive reform. The concept of a statutory exemption for a certain number of buildings on a single tract is essential to that reform to provide landowners with a stable and predictable rule that they can rely on, to acknowledge and recognize that there are a de minimis number of units that can be constructed on a single tract without causing impact, and to prevent abuse of the process through unnecessary regulation of small projects which should be allowed to go forward under a much simpler process. This bill, as Senator Rosendale mentioned, eliminates the definitions of division of land, or eliminates from the definitions of division of land and subdivision, as set forth in the Subdivision and Platting Act, the concept of a transfer of possession, and restricts the definition of subdivision to a transfer of title. So the bill also removes the concept of buildings for rent or lease from the Subdivision and Platting Act and relocates them in another chapter of the code where they can be dealt with separately, more effectively, under a designed set of regulations and rules. And this was done to eliminate confusion and under the premises that subdivisions are created, as I mentioned before, when there's a transfer of title, but not necessarily when there's a transfer of possession. To conclude my remarks today, and I want to thank you for your time, this bill was carefully considered and thought out. It is balanced insofar as it provides the necessary exemptions to help landowners where subdivision review is unnecessary, but it also provides specific review processes and regulatory requirements for local government where subdivision review is necessary and is appropriate. It provides a statutory minimum number of exempt buildings, but allows local government to increase that number on a jurisdiction-by-jurisdiction basis if a particular local government deems in its discretion that it would be appropriate to do so. And it requires local government to adopt regulations containing specific minimum review criteria for non-exempt buildings with specifically defined procedures for completing review of non-exempt projects. And it appropriately distinguishes between structures which are intended for rent or lease and those which are not. I'm very pleased to be here today in support of this bill. I very strongly believe that it's time for all of the groups and people who've worked hard and have participated in this process to come together and support what is a reasonable solution to a problem which has plagued Montana for years. It is time to fix this. And so for those reasons, and on behalf of the Montana Association of REALTORS, I urge a due pass of this bill.